Good afternoon. I'm Ryan Johnson, and I'm here with my colleague Katie Ilten to talk to you today about telemedicine heading into 2020, updates on legal, reimbursement, and compliance issues. Before we get into it, a couple of housekeeping items. If you have any questions, please use the chat box on your screen. We'll try to get to all of your questions. If we don't do so, we'll try to follow up with you after the presentation. Our next webinar will be on December 11th, which will be on the key provisions on the 2020 Medicare fee schedule. I'll also probably cover the pricing transparency rule and talk a bit about the new proposed, the new Stark exceptions. So in today's webinar, we're going to give you an update on the key legal and regulatory issues you have to consider when structuring telemedicine arrangements. Now, at a high level, telemedicine is covered by three categories of laws and regulations. Some of those cover safety of patients, for example, rules and regulations that apply to medical devices, including software as a medical device, rules that govern licensure, scope of practice, and credentialing, as well as the corporate practice of medicine. There's also a category of laws that really is designed to protect patient and consumer data, including the privacy and security of data, and today we'll talk a bit about HIPAA, the accuracy and integrity of data, and again, inappropriate commercial exploitation of data. The third category is really focused on patient and consumer transparency, deal with consent and choice. And so with respect to that, we'll talk about consumer protection laws, direct-to-consumer advertising, and some other laws and regulations. Now, there are other laws and regulations we won't be covering in today's presentation, but it will be important to consider when structuring a telemedicine arrangement. But today we hope to give you a good sense of the key laws and regulations to get you started. So to level set, let's start by defining telemedicine. So telemedicine is the use of electronic communication technologies to provide clinical services to patients without an in-person visit, with the goal of improving the patient's health status. The electronic communications or monitoring may be used for follow-up visits, management of chronic conditions, medication management, consultation with specialists, or other clinical services that can be provided remotely via secure video and audio connections. That's the definition we'll be using for purposes of today's webinar. However, it's important to note there's no uniform definition of telemedicine. State laws will partially dictate what constitutes telemedicine, at least for purposes of their licensing and regulatory schemes.
And I'll just mention here that you'll hear us use the word telehealth in some instances, and I think we'll try to be specific to use the telehealth. Where the telehealth has a specific definition, we'll be sure to point it out. Certainly in the Medicare context, telehealth is narrower than the telemedicine definition that Ryan just gave you.
Great. So question, how does telehealth fit into the digital health ecosystem? So as I'm sure everyone on this webinar knows, digital health, including digital health products, including artificial intelligence and machine learning, digital therapeutics, the Internet of Things, remote monitoring, telemedicine, these technologies are transforming healthcare, providing consumers with greater control over their health and wellness, creating new platforms for reducing the cost and improving the quality of healthcare through the use of data, and transforming, at least in part, many healthcare stakeholders into data companies. At a minimum, emerging digital health technologies are forcing healthcare companies to view the vast amounts of data they have collected as an asset with substantial clinical, financial, and strategic value. Now, the ability of these companies to realize that value, however, depends on a number of factors, including their understanding of existing legal and regulatory barriers and opportunities for digital health implementation and data use, and federal and state barriers. Unfortunately, as is often the case, the existing state and federal regulatory landscapes are rapidly evolving, but not as fast as the emerging technologies. They're not a perfect fit for the rapidly evolving world of digital medicine. So each of the digital health technologies you see on the screen, health apps, connected devices, automation robotics, consumer apps and wearables such as Fitbits, health IT and services, telemedicine, et cetera, these are all part of an interrelated digital healthcare ecosystem. Now, as many of you are aware, the lines of demarcation between these technologies is often blurry, and digital health solutions are rapidly becoming combinations of two or more of these component technologies. This is also true with telemedicine, as many companies and providers seek to leverage the use of telemedicine technology with remote monitoring, wearable technologies, IoT-connected devices, and at-home diagnostic tests, with many of these technologies being powered, at least in part, by machine learning and AI-based algorithms. So we're going to talk about a couple different types of telemedicine over the next several slides, including store and forward or asynchronous telemedicine, remote patient monitoring, and real-time services. So first, store and forward or asynchronous telemedicine involves the electronic transmission of patient data among providers at different locations. It's a secure way to share information, and it's asynchronous, meaning that providers do not need to be reviewing the patient records at the same time. Now, asynchronous or store and forward telemedicine is best suited for consulting with specialists or other external resources. And examples include teleradiology, in which a smaller facility can send x-rays to a remote radiologist for review and diagnosis. Teledermatology, in which a primary care physician can take a picture of a skin condition and send to a specialist for consultation or for e-consults and second opinions. Now, the benefits of this type of telemedicine is that patients can obtain specialty care even if it's not available in their particular geography. It's often faster and more cost-effective than seeing a specialist. And I'll note before going to the next slide that there are some telemedicine platforms that are using asynchronous telemedicine platforms to communicate with patients. But that's not the primary way this technology is used. So remote patient monitoring. This involves the collection of health data from a patient in one location and the transmission of the health data to a provider in a different location. This can be done with active and live monitoring information to flag for issues. Alternatively, providers can receive reports of collated data for better ongoing care, and it's often used for chronic care management. Examples, monitoring vitals, monitoring blood pressure, glucose levels, heart rate, pulse, sleep patterns, weight, etc. Now, the information with remote patient monitoring is often gathered from wearable and mobile devices. The benefits of remote patient monitoring: it can help identify issues quickly before they develop into bigger problems, and it can help providers better understand patient behavior. Now, the risks: these wearable devices, many are coming to the market very quickly. They're fairly new. They're unproven applications, but there are many benefits to these technologies. All right, so telemedicine involving real-time services. This is live two-way video encounters between a patient and a provider or between providers. It's often referred to as Skype medicine, but with secure private connections and HIPAA-compliant technology. Real-time telemedicine is often used for primary care, urgent care, or follow-up issues. Examples include patients using real-time telemedicine if they have suspected pink eye, ear infections, influenza, rashes, respiratory infections, or lice. Another example, teleneuro, involving strokes, sepsis, or cardiology. The benefits of real-time telemedicine: it's convenient, it's fast, it's cost-effective for patients, provides an opportunity to get immediate treatment, and it's not limited to physicians in the patient's immediate area. And the risks involve managing patients from distant locations. Now, there are many types of agreements you see in various telemedicine arrangements, depending on the nature of the arrangement and the various participants. There are telemedicine service agreements, credentialing and privileging agreements, equipment lease or purchase agreements, technology or software licensing agreements, data use agreements, of course, business associate agreements, management service agreements, website terms of use and privacy policies, etc. Now, obviously, the format and terms of these agreements and policies are very different, but there are some common provisions in many of these agreements, and we'll share some of those later in the webinar with some tips when negotiating and drafting those agreements. Just a quick statistic. Kaiser Permanente is one of the national leaders in telemedicine, and as far back as 2015, of Kaiser Permanente's 110 million interactions between physicians and members, already at that point, 56% were virtual, surpassing physical visits for the first time. So it's a very powerful technology being adopted by large and small healthcare providers and other companies with tremendous clinical value. All right, moving on to legal and regulatory issues. So one of the first issues to consider when structuring telemedicine arrangements is required state licenses. Practitioners must meet the licensing requirements in the state where the patient is located. Now, it's the key issue in almost any telemedicine arrangement, and state laws vary regarding, in terms of how they deal with telemedicine at the licensure level. Now, some states' licensing laws directly address telemedicine and explicitly define the practice of telemedicine. Some states indirectly address telemedicine by defining the practice of medicine to include diagnosing or recommending treatment through electronic means. And some states are silent. Now, as you see on the slide, 48 state medical boards plus the District of Columbia require that any physician providing care to patients via telemedicine is licensed in the state where the patient is located. There are a couple of exceptions you see to that general rule, Kansas and New Mexico. 15 states, including Minnesota, have a special purpose telemedicine license, and 28 states have certain exceptions to the licensure requirement for infrequent or occasional consultations. 5 states define what occasional and frequent means. Delaware means fewer than 6 consults per year. New Mexico, it's no more than 10 patients per year. In Wyoming, not more than 7 days in any 52-week period. I think one of the big issues to look at is making sure that the practitioners, those who are going to be providing the telemedicine services, are appropriately licensed. You'll have to look at the state law, largely where the patient is located to make that determination. And again, part of the analysis is also looking at what types of practitioners are providing the services, whether it's physicians or other licensed healthcare professionals.
So we're going to stay mired in the state law for a little bit because this is a lot of the legal work that has to be done when you're structuring telemedicine arrangements. And not only do you need to look at whether the practitioner who's providing the service has the appropriate licensure, certainly you have to make sure that the practitioner is limiting what they're doing via telemedicine to what's in their scope of practice. You certainly can't do more than what you could if you were in person with the patient. That seems pretty obvious. What's less obvious is that, again, varying by state, state laws may limit further what a practitioner can do via telemedicine. If they are in person, they might be able to do a particular assessment, but via telemedicine, there may be a narrower scope. So, for example, the most common one you hear about is that some states require in-person encounters before providing telemedicine services. That's definitely the case in many states for prescribing, but could also be that a state may require you to have had an in-person encounter before doing further encounters that don't involve prescribing. So the devil's in the details. So be aware that the definition, you can't just look at the definition of practicing medicine or practicing a profession in a state. You would also need to be looking at whether there's a definition of permitted telemedicine. And this I found to really be true with respect to non-physician practitioners. Many states do permit non-physician practitioners to practice telemedicine expressly, but just because a state might permit a PA or an NP to do telemedicine services to patients in that state, it doesn't mean that other types of practitioners like behavioral health practitioners or clinical psychologists could similarly practice via telemedicine. So it varies by state, and then it's going to vary by the various practice acts in each state. In many cases, particularly for non-physician practitioners, the Practice Act is just silent with respect to telemedicine services, and so you have to do some interpretation of what the law says with respect to what can be done on the ground and decide whether there's a reasonable argument that it could also be done via telemedicine. What's especially tricky in those situations is that you may have an out-of-state non-physician practitioner who can do telemedicine, do a certain thing via telemedicine to a patient sitting in another state, but the state may also require some level of supervision of that non-physician practitioner, supervising a PA, for example, or an NP. And so then it's not just a question of what license and scope of practice permits for the practitioner providing the telemedicine, for example, the NP or the PA in our example, but what also is permitted and what is required for the person who's supervising that NP or PA. Does the physician, for example, who's responsible for supervising that NP or PA, do they also need to be licensed in the state where the patient sits? So as you get into different areas of practitioner, be aware that practitioners who aren't fully independent or who may not be fully independent practice in these states are going to have another layer of supervision that may require you need to do some extra things for the folks who are going to be supervising them. Some states have an express statute that says that the standard of care with respect to telemedicine is just the same as the standard of practice and conduct for services provided in person. That seems sort of obvious, but that means the state may expect that you're following record-keeping requirements, notice requirements, and things that you would have to follow if you were practicing on the ground if you're providing them via telemedicine. Telemedicine and prescribing doesn't get much easier in terms of figuring out what you can do in various states. Similar to licensure statutes, many prescribing statutes were written before the widespread use of telemedicine, and many statutes are vague. Where they are clear, many states require a physical exam or a pre-existing physician-patient relationship prior to prescribing, and that can be difficult when you are providing services via telemedicine. Now, some states will permit the use of telemedicine to conduct that exam and to establish a physician-patient relationship. And so you're going to be looking in the statutes for what is required to establish that relationship and whether that can be done via telemedicine or whether you first need an in-person exam by someone. Most states, however, do say that just having an internet online questionnaire is not sufficient to establish a patient-physician relationship or patient-practitioner relationship that's inadequate. And so there's going to need to be some additional interaction beyond a questionnaire, but whether or not it has to be in person or can be provided by someone else is going to vary based on the states. So, for example, I know we have people from all over the country here, but just as an example, in Minnesota, we have a statute that does incorporate the elements of telemedicine, but still says that in order to prescribe certain controlled substances and legend drugs, then you need to have a documented patient evaluation, including an examination that's adequate to establish a diagnosis. Now, if that was the only language, you would have an interesting question about whether you could have the evaluation done via means of telemedicine. In Minnesota, the legislature's answered that question by clarifying further that the in-person examination, they really do mean in-person, but there are some exceptions to that. And the exception that relates to telemedicine says that a referring practitioner, so if there's a referring practitioner who's referring to a consultant, and the consultant is providing the services via telemedicine and providing the prescription, that consultant practitioner need not do the in-person examination if the referring practitioner has done it in that case. So that's one example of a way that telemedicine is allowed, but there's a limitation on the prescribing and what is needed to do to prescribe the medication. Other states have relaxed laws even more around online prescribing, and so some states have opted to explicitly allow for the prescribing of controlled substances within the federal limits. So they've just used the floor of the federal law in establishing the requirements. Many of those laws have been passed as a result of the opioid epidemic and the need to be able to prescribe certain medications associated with medication-assisted therapy. So I think West Virginia, for example, has passed legislation that allows a practitioner to provide some aspects of medication-assisted treatment through telemedicine if it's within their scope of practice and if they're meeting the federal rules. New York has done a little bit of that as well. I've got a question here that the questioner is asking if we can send out a list of the states that have special purpose or exceptions for occasional or infrequent occurrences. This was what Ryan, I think, brought up about licensure and whether you need to be licensed in states to do telemedicine. So there's a link here in the next few slides to a pretty good resource on state laws and prescribing and telemedicine. And so I would certainly direct you to, if you're looking for high level, to that link that keeps pretty up to date on the state laws and that can help at least get you started in answering some of these questions. So the other complicating factor about prescribing in telemedicine is that we have a federal law passed about a decade ago that addresses this issue, and this is the federal Ryan Haidt Online Pharmacy Consumer Protection Act 2008, which was really designed to get rid of those bad rogue internet pharmacies who were basically selling controlled substances online without any sort of interaction with the patient. And so it basically prohibits online prescribing for controlled substances, but does allow a prescriber to prescribe a controlled substance via telemedicine if the practitioner has conducted an in-person exam, so back to where we started with needing to be in person, or they meet a practice of telemedicine exception. Now, unfortunately, or fortunately, depending on what issue you're tackling, the practice of telemedicine exceptions are fairly limited and aren't allowing the types of teleprescribing of controlled substances that the industry is wanting to do, particularly in response to the opioid epidemic. The exceptions would allow the prescriber not to have done an in-person exam if, for example, the patient was located in a hospital or a clinic with a DEA registration. If the patient was sitting real time with another practitioner who's doing the exam and then the telemedicine practitioner prescribes. There are a couple other very narrow exceptions for Indian Health Service or public health emergencies. But what these exceptions don't cover is the situation where a patient's at home or at school or at work. In those situations, the federal law prohibits a practitioner from prescribing a controlled substance via telemedicine. Now, there is an opportunity here. One of the exceptions is where the DEA has issued a, quote, special registration. In 2018, when the President signed into law the SUPPORT Act, which was the act that was aimed at combating the opioid epidemic that gave us ECRA, that statute does include a requirement that the DEA promulgate rules within a year. So actually, by very recently, they were supposed to have promulgated rules that gave some special registration that's hopefully designed to expand the situations where a patient can receive controlled substances or be prescribed controlled substances via telemedicine. We haven't seen those yet, but in the rumblings that I have heard, the DEA is supposedly working very quickly on those. And so stay tuned because we may see more opportunities for prescribing controlled substances in the coming months. So we'll switch gears a little bit to talk about reimbursement for telemedicine services. This is, again, another area where reimbursement is going to depend on state law, which governs both Medicaid coverage and commercial coverage and commercial contracts, and then also the federal law with respect to Medicare. So as I always say, with private pay or commercial pay arrangements, it's important to look at your contract and your provider manual to understand what circumstances telemedicine services will be reimbursed. Similarly, state Medicaid programs have a variety of approaches to covering telemedicine services. Now, many states have adopted parity laws that say certain services that are paid for should also be paid for even if they're provided via telemedicine. But those laws aren't necessarily uniform, so it does require digging in. The link that I have here is, it goes to a trade group that has a lot of good resources on current state laws and policies with respect to telemedicine. So I would use that if you're kind of doing a broad brush and trying to drill into specific states' practices. In general, Medicaid, if I was painting broad brush strokes, the type of telemedicine that's most likely reimbursed by Medicaid programs or most frequently reimbursed by Medicaid programs would be the live video telemedicine service, the two-way interactive video and audio. I think nearly all 50 states have reimbursement for some form, for some services provided with the two-way interactive video and audio. Maybe about half the states' Medicaid programs also reimburse for the remote patient monitoring in some context. Fewer states, probably 15 or so, also cover the reimbursement for the asynchronous telemedicine or the store and forward technologies. Not many Medicaid Medicaid programs are reimbursing for that, but some are. What we're also beginning to see is that homes and schools are being added as eligible originating sites, i.e. sites where your patient can be when they receive the service. That's becoming more common across private pay and Medicaid programs. And certainly the inclusion of substance abuse disorder services as a specialty that qualifies for Medicaid reimbursement and by private insurers. So there are trends, but again, it's piecemeal depending on the jurisdiction and the payer. On the Medicare side of things, we need to think about the term telehealth and telehealth delivered services, because that is a defined term by the Medicare statute and governs what will be paid by Medicare. And Medicare has significant limitations on what it will cover for telehealth services, limits where they can be provided, by what technology, and by patient locations. So generally, specifically, these types of practitioners are the practitioners who can provide telehealth services for Medicare purposes. Medicare limits what sorts of services are paid for as telehealth services by saying that they will only pay for the interactive two-way audio video, so your Skype situation. Medicare is not at this time, with some exceptions that I'll discuss, but the list of covered telehealth codes that is updated each year in the physician fee schedule, that list of approved codes for telehealth services does not include coverage for any sort of asynchronous or store and forward services. That's only permitted in certain demonstration projects. So for Medicare purposes, you have to be doing two-way audio, visual, interactive. You have to be providing, in order to get paid, you have to be providing a service that's on the list of covered CPT codes that are telehealth services. And you have to, there are certain geographic requirements. So in general, the patient must be located in one of the following approved originating sites. So they have to be in a doctor's office, they have to be in a hospital or critical access hospital, RHC, FQHC, a dialysis unit, a SNF, or a community mental health center. So not on this list of originating sites is home, school, or work. In addition, the originating site, i.e. where the patient is, has to be in basically a rural area. That is, they have to be outside of a metropolitan statistical area, which you can find those areas on the Census Bureau website. Happy to send you a link if you need it. Or you need to be in a health professional shortage area. So Medicare has really narrowed down the list of who, what, when, and where the services for telehealth will be covered. Now, there have been some exceptions that have come through in the past few years. You can have the patient be at home in certain circumstances. End-stage renal disease patients who are getting home dialysis can get telehealth services when they're at home. And just effective in July of this year, Medicare started to pay for telehealth for substance abuse disorder or co-occurring mental health disorder where the patient was in any jurisdiction, not just in a shortage area or outside of an MSA, and that they are at home. And so that's just a change that's become effective in the last several months. I'm going to go over a couple of the updates that we've seen both last year and then what we will see in 2020, because I think that even the ones that came out last year are still not terribly well known to everyone. Again, new in 2019, we have teleneuro for stroke services. For acute stroke services can be provided anywhere, no geographic or originating site restrictions. So any jurisdiction, any location, whether they're home, work, and you don't have to be in essentially a rural area. So real quickly, I've talked about how this billing works. There's an originating site fee, facility fee, where the site where the patient is gets to bill that site or that fee, presumably for the infrastructure and care that they've provided and to the patient during and prior to and during the telehealth encounter. Obviously, we can't charge a fee if the patient is at home. And then the distant site practitioner who's providing the service via telemedicine has a charge that they submit. This is the same payment amount that would be paid if the practitioner providing the service was in person. There is a special place of service for telehealth. And if you're sitting outside of the jurisdiction where the patient is, for Medicare payment purposes, you want to make sure you are submitting to your own practitioners, to your own Medicare administrative contractor. So in 2019, so these changes were effective about 12 months ago, in 1/1/2019. CMS added a couple CPT codes to the list of covered telehealth services. So again, we're still in the situation where you have to be in an MSA, outside an MSA, or in a health professional shortage area. So they added 2 additional codes that covered telehealth services, the prolonged preventive services codes, which basically is the time that's spent beyond a typical service of the primary procedure in the office or outpatient setting for the first 30 minutes and then each additional 30 minutes. Those were approved as codes for telehealth. If your telehealth encounter goes longer than would typically require, then those are now on the list of what the practitioner can bill for. They added the ESRD assessment telehealth services can now be provided in home and at renal dialysis facilities. And then, as I mentioned, the mobile stroke units are originating sites, no geographic requirements, so don't have to be in an area that doesn't have a lot of health care available. What was really interesting about last year was that CMS decided they wanted to attempt to increase the access to physician services that are not necessarily what Medicare defines as telehealth services, so not necessarily two-way interactive audio video, but services that are contributing to the patient's health care, particularly in the preventive sense. And so they added a few codes for 1/1/2019 that are designed to get at those situations. So these codes can be billed without regard to the restrictions on Medicare telehealth services. So you don't have to be outside an MSA, you don't have to be in a healthcare professional shortage area, and you don't have that those originating site limitations. So those codes were, the first one is called Brief Communication Technology-Based Service, i.e. virtual check-in. And so basically what this is a brief check-in where the billing practitioner, so not the office staff, but the billing treating practitioner talks to the patient for 5 or 10 minutes about their medical condition. If that happens and you meet the other various requirements, the practitioner can bill for that virtual check-in. Now, there are some limitations to this. It can be over the telephone, but you could also have some two-way video enhancements. But you can have a telephone call if it's by the billing practitioner. And you also, but you also can't get paid for this if the virtual check-in happened within the 7 days prior to an E&M service or within 24 hours after. So if you're outside of that window and you meet these other requirements, you can bill for that 5 to 10 minute medical discussion that's a virtual check-in. Note that there are a couple other requirements, like you need to there is a patient copay for that check-in, and you need to have patient consent for this service, but the consent could be given via the phone. So make sure that that's documented in the chart. And again, this is only for established patients. The next code that was added was the remote evaluation of recorded video and or images submitted by an established patient. So this is the established patient who's sending video from maybe a monitoring device or images of something that they have going on, and the practitioner is looking at them and doing some medical evaluation. So again, there are some specifics around this. It can't happen in that 7 days up to an E&M and 24 hours after. The patient has to consent to being billed for this because they are going to have a copay. But again, that exchange of data that's not necessarily done in a two-way audio-video setting is increasingly being recognized by Medicare as something worthy of payment. And then the other one that I'll just touch on briefly is the interprofessional internet consultation. So basically, this is like a consulting situation where the referring practitioner provides some images or data to a consulting practitioner, and in certain circumstances, both of those practitioners, the referring and the consulting, can bill for the service. This is usually done telephone or internet, and there have to be, there are also time limitations, and both the codes require a verbal and a written follow-up report. But again, another example of something outside of the traditional in-person setting that has been recognized by Medicare. Briefly on 2020 updates, so this is the fee schedule, and you'll hear more about this in our December 11th webinar, but there are a couple more telehealth services being added to the official list of Medicare services. So again, we're back in the situation of needing to be in a certain area, i.e. not in an MSA or health professional shortage area with an appropriate originating site. But there are now some bundled episodes of care for the treatment of opioid use disorders that are going to be introduced generally for in-person that are also going to be added to the list of telehealth services that are covered by Medicare. So we can get more into the weeds of that in our December webinar, but be aware that those are the adds to the 2020 CMS update.
All right, moving on to fraud and abuse. It wouldn't be a health law webinar without some discussion of fraud and abuse. As most of you know, telemedicine arrangements must comply with federal and state fraud and abuse laws, including federal and state anti-kickback statutes and self-referral prohibitions. So the federal anti-kickback statute prohibits the offering, paying, soliciting, or receiving any remuneration in return for business for which payment may be made under a federal health care program, Medicare, Medicaid, or TRICARE, or inducing purchases, leases, orders, or arranging for any good or service or item paid for by a federal health care program. A remuneration is defined very broadly to include kickbacks, bribes, and rebates. It can be paid in cash or it could be in kind, and the remuneration can be direct or indirect. The penalty for violating the anti-kickback statute can be quite significant. There are criminal and civil penalties, potential imprisonment, False Claims Act exposure. So it's important to make sure that telemedicine arrangements are structured in a way that complies with federal and state anti-kickback prohibitions. Now, in the telemedicine context, it's important to look at a number of relationships, including any relationships between outside supervising or collaborating physicians, as well as relationships with other third-party entities, management companies, telemedicine entities, equipment and technology vendors, etc., to make sure those arrangements are not structured in a way that would violate the federal anti-kickback statute. Now, quickly, if the telemedicine arrangement does not involve any federal health care program reimbursement, there's not going to be a federal anti-kickback issue. But remember, many states have their own version of anti-kickback prohibitions. not tied to Medicare, Medicaid, or TRICARE reimbursement. So it's important when structuring these telemedicine arrangements to make sure not only that they comply with the federal anti-kickback statute, but any applicable state anti-kickback prohibitions. Now, thankfully, under the anti-kickback statute, there are many safe harbors. And if arrangements are structured to fit within one of the safe harbors, for example, the rental of space, rental of equipment, for personal service or management contracts, those arrangements are protected. Now, you don't have to be in a safe harbor. If you're outside, there's some amount of risk. And, but if you're inside a safe harbor, you're safe. Now, the OIG often issues advisory opinions on a variety of arrangements. And those advisory opinions can be used to help guide you and your clients in structuring telemedicine arrangements in a way that comply with the federal anti-kickback statute. Now, historically, the OIG has provided favorable treatment of telemedicine arrangements. And you see a list of the opinions on the slide. Recently in 2018, in 1803, the OIG approved an arrangement involving a federal qualified health center that was providing free equipment to a county clinic for telemedicine encounters related to HIV prevention. The OIG know that the anti-kickback statute was implicated, but there would not be any sanctions imposed. So I think it's worthwhile when structuring these arrangements to consult these advisory opinions to help guide the drafting and structuring of the arrangements.
So another issue that comes up on both this is tied to reimbursement, but also scope of practice licensure, is patient consent. So be aware that I think something around 38 states, last time I read about this, require some sort of informed consent documentation in their statutes or rules or Medicaid policies. So sometimes the requirements are a Medicaid program requirement, sometimes it's a licensure requirement or ethical obligation that the board of the practitioner thinks should happen. But most states have that buried somewhere in some context, and they differ. So, for example, Arizona Medicaid requires a consent if there's going to be a recording of an interactive video service, while Idaho requires a consent that discloses some specific things, such as the delivery models for the telemedicine, the provider qualifications, the treatment methods, and then any limitations on the telemedicine technologies being used. So the types of things that might come up that might be required as part of that consent include information about and credentials and qualifications of the person providing the services, what's being used in the encounter, the risks of the information, lost connection, limits of the technology, those sorts of things. So be aware of that, and if you're looking to do an expansive multi-state project, it might be worthwhile just to have a very robust consent to hit all of the bells and whistles or all of the hidden requirements that may be across the states. We won't spend a lot of time on HIPAA and privacy and security. We have a lot of webinars on privacy and security and HIPAA requirements. Telemedicine does not exist outside of HIPAA. In fact, it's squarely within and regulated by the privacy and security rule, and information going across being used in those technologies is protected health information. And certainly, telemedicine providers are not exempt from doing all of the things that covered entities and business associates have to do if they're providing services on the ground. I think kind of the low-hanging fruit and things that will get you into really big trouble but are fairly easy to implement, but that often get missed are it seems obvious, but you need to have a business associate agreement with any vendor who's facilitating your telehealth encounter. And you need to have consents. Oftentimes the consents will cover privacy use of information that needs to be addressed. and how a vendor can use the information that it obtains from a telemedicine service after the encounter, and whether that relates to patient care or is beyond that. So the consent about the use of information is important. The other thing that I see clients miss a lot is incorporating the telemedicine program into the covered entity security risk analysis or business associate security risk analysis. So obviously you should have an enterprise-wide security risk analysis under the security rule. Don't forget about the telemedicine vendor because it's just as much part of your organization if there's a breach. The first question is always what happened, and the second question is always can we see your security risk assessment when the Office of Civil Rights comes in the door? So make sure all parts of your business, including your telemedicine program are on that. And then finally, in addition to needing a business associate agreement and things like that, your website, like if you're doing virtual care platforms, your website probably needs a privacy statement, terms of use, and so think about those ancillary privacy documents that are going to be relevant if there's ever an issue.
All right, moving on to direct-to-consumer advertising. A number of telemedicine platforms market their services directly to consumers. So if that's the arrangement you're trying to set up, it's important to understand some of the legal and regulatory issues that apply to direct-to-consumer advertising. First, some telemedicine arrangements might involve a device that's subject to FDA jurisdiction, including the software that is treated as a device under the FDA's guidance. It's important that any claims that are made, if the device or the telemedicine offering is subject to FDA jurisdiction, that the claims are consistent with the FDA's approval process. The Federal Trade Commission also enforces the FTC Consumer Protection Law, which prohibits unfair or deceptive trade practices. Now, this applies to anyone who's marketing, services to the public or to the consumers, including healthcare companies. And the FTC is concerned about unfair or deceptive health claims, as well as unfair or deceptive claims relating to privacy and security of the platform or technology being used. Now, I'm going to use an example that I think might illustrate how this works in practice. So Lumosity is a company that many of you are perhaps familiar with. It was very popular in the recent past. And the creators and marketers of the Lumosity brain training program were hit by the FTC on charges that they deceive consumers with unfounded claims that their games could help users perform better at work and school and reduce or delay cognitive impairment associated with their age and other serious health conditions. Now, the FTC noted that Lumosity preyed on consumers' fears about age-related cognitive decline and suggested their games could stave off memory loss, dementia, Alzheimer's disease, etc. But Lumosity did not have the science to back up its ads. The FTC alleged that the defendants claimed training with Lumosity would improve performance on everyday tasks in school, at work, and athletics, etc., and again, delay the onset or prevent the onset of these conditions: cognitive decline, dementia, Alzheimer's, etc. The important thing here is that the Lumosity makers and marketers did not have data or science to back up the claims, and the FTC again said that their claims were therefore unfair or deceptive. Now, the FTC's consumer protection law does not just apply to advertising; it's all communications. So the telemedicine platform is making claims about the clinical efficacy of their offering, if it's a digital therapeutic telemedicine platform, or if the company is making claims about how it uses user, patient or consumer data, where its servers are located, et cetera. All of those types of claims that can be found in terms and conditions of a website or policies, those are subject to FTC jurisdiction. And if the claims that are made in those policies, on those sites, and other documentation are unfair or deceptive, well, those making the claims could be subject to penalties similar to those that Lumosity was forced to pay. So those are the big federal laws. Many state laws have their own advertising laws and regulations that need to be consulted when structuring telemedicine marketing or advertising arrangements. All right, the corporate practice of medicine. There are some telemedicine companies that are offering a variety of services, and those services include clinical services. It's important to consider the corporate practice of medicine prohibition, which exists in about 35 states. So the corporate practice of medicine prohibition prohibits corporations from employing medical professionals or owning or controlling medical practices or medical decision-making. Now, the prohibition was designed to prevent laypersons, non-licensed individuals, from exerting control or influence over physician medical decision-making. Now, this prohibition has been widely criticized as being out of step with the way healthcare is delivered today, but it still is the law in the majority of states. So where you find the prohibition depends on the state. Some states have express statutes prohibiting the corporate practice of medicine. Sometimes you have to look into case law or attorney general opinions or medical board policies to find the prohibition. But if it exists and it applies to your telemedicine arrangement, it's important to find a way to structure that arrangement to comply with the corporate practice prohibition. Now, the enforcement of the prohibition varies on the state, on a state-by-state basis. Some states are fairly loose and passive in enforcing the prohibition, and others are much more active, including California and New York. Now, there are exceptions to the corporate practice of medicine prohibition. Some common ones include hospitals, sometimes other licensed entities. And a very common exception is entities owned solely by licensed professionals. For example, professional corporations owned by physicians. Technically a corporation, which would otherwise be covered by the corporate practice prohibition in some states by its definition. There's often an express exception for entities solely owned by licensed professionals. So potential solutions if there's a corporate practice prohibition issue. The management company model is often used, where you have a professional entity that fits into that exception I mentioned, owned exclusively by licensed professionals. That entity employs the licensed professionals, is owned by the licensed professionals, and is responsible for clinical decision-making. You'd also have a management company involved in the arrangement, and that management company is responsible for non-clinical functions under a management services or administrative services agreement, and that could include providing technology, providing advertising support, doing a variety of non-clinical things for the professional corporation, but the professional entity will be the one responsible for providing all the professional services. So just briefly, fee splitting. When structuring compensation arrangements in telemedicine arrangements, it's important to consider state fee splitting prohibitions. This is somewhat analogous to the anti-kickback prohibition I mentioned earlier. This is often found in the professional ethics applicable to licensed professionals. There are oftentimes state-specific prohibitions on fee splitting as well. And again, it arises from the perceived danger of allowing professionals and non-professionals to share an income from professional services. Two concerns: there's a temptation potentially to maximize profit through medically unnecessary services, or a temptation to limit medically necessary services to maximize income. So again, the fee arrangements are very important to analyze when structuring telemedicine arrangements, both for federal and state anti-kickback issues, self-referral prohibitions, as well as state-based fee-splitting prohibitions. Quickly, a couple risk mitigation and contracting tips. Now again, earlier in the presentation, we had a list of various types of agreements that are often used in telemedicine arrangements. Here are some typical types of issues to consider and terms to consider including in your contract. First, if the arrangement includes the provision of clinical services, it's important to consider the following questions. What services will be provided? Which type of providers will provide the service at which location? Will the other contracting party assist in the implementation of the service? If so, to what extent? Will support staff be designated to facilitate telemedicine services, and who will provide training to the staff? Who will develop any clinical protocols for use by any telemedicine provider and any licensed support staff? Who will ensure the maintenance of necessary licenses, accreditation, and credentialing? And who's responsible for maintaining patient EHRs? The answer to those questions will also be relevant in analyzing, the legal issues we've talked about today. But once those questions have been answered, it's important to address those in the contract. If the contract involves purchasing or installing or maintaining software, some basic questions to consider. Who is responsible for purchasing, installing, and or maintaining the telemedicine equipment? Are there any state technology requirements to consider that have to be addressed? What about access to support services or technology updates? And what do you do if the technology goes down? All those questions should be addressed in a technology agreement. If the agreement involves education and training, again, what's needed, who's going to provide it, on what terms? And with respect to vendor equipment or software arrangements, some basic, tips. Think about the licensing terms, termination provisions, indemnification, et cetera. Interoperability, obviously a big issue, making sure the systems work together, the telemedicine system with the existing EHR or other, software being used by the licensee. Again, what access you have to support services or technology updates. It's important to have the vendor represent and warrant any technology or software's compliance with regulatory requirements and have the appropriate type of indemnification provision tied to that. Also recommend having appropriate insurance in place to stand behind the vendor's obligations, including indemnification obligations of the contract. With respect to IP, a big issue, questions who owns and gets to use the data. And of course, there are federal and state privacy and security laws and regulations that limit what the parties can agree to. But once you get past that, there are other strategic considerations. Even if the law would allow you to share the data or allow the other side to own the data in some fashion, it doesn't make strategic or financial sense to give the other party those rights. And I think just a number of organizations are just starting to think about the strategic value of the data they have as being really a valuable asset of the organization. And so it's not just about making sure these agreements are compliant with state and federal law, privacy laws, et cetera, but making sure that some thought has gone into what sort of data rights you want to maintain or give away to the other party in a telemedicine arrangement.
All right, so we are near the top of the hour, but we have a couple questions here. So please do send them in. Before most people hop off, I'd like to encourage them to fill out the survey. Please know that your answers to our survey are anonymous. We don't know who you are unless you tell us, and that's good because we want you to be frank. But if in one of those questions you say, I want you to call me, but you don't tell us who you are, it will be hard for us to call you. So if you are asking for us to reach out, please make sure you find a way to tell us who you are and that you need us to call you. All right, so let's see. So one question, this is a really good question. Do CMS telemedicine billing regulations address incident to billing? So great question and a little tricky. So when we're talking about the telehealth services that are defined and that have those very specific geographic limitations, I don't think that there's anything that talks about whether they can or can't be billed incident to. And so I would say that with, absent a regulation that says they can't be billed incident to, you could do that. I think the question is whether you can meet those other incident to requirements, which requires, the course of treatment be initiated by the billing by the physician, for example, and then with the NP following up via telehealth, the NP would have to follow up, not start the course of treatment if the NP was the one who was providing the services. And then also, in order to bill under that physician's number for those follow-up services, there would have to be a physician present in the office suite. And so you still have those incident to requirements that you'd need to meet in order to do the telehealth services incident to. Now, with respect to the virtual check-in communication-based technology service, which CMS has said are not telehealth, i.e. the phone calls, the internet consultation, in those circumstances, CMS, the CPT codes are very specific, and CMS guidance is very specific about whether they can be performed by auxiliary personnel. So the virtual check-in, we do have language in that that says it can't be performed by office staff. But recently, I suppose it was last year, but when the remote patient monitoring code came out, in that circumstance, CMS expressly clarified, they went back and revised the language of the code to make sure that it removed any prohibition in order to allow people to do incident to billing for remote patient monitoring. So again, you have to meet the direct supervision requirement and all the other incident to requirements. Now, a development that you'll hear with remote patient monitoring, which last year was clarified to allow to be done incident to, this year I believe that the fee schedule says that going forward, you need not meet direct supervision requirements, but you can have general supervision, which basically means the auxiliary personnel who's doing the remote patient monitoring doesn't need to be sitting in the same office suite as the supervising practitioner, supervising physician. So that's another loosening of restriction on how you can do incident billing in the kind of virtual communication-based technology codes. Another question is there a resource that indicates an ineligible telehealth service is statutorily excluded? I think the questioner is trying to get at whether you need to, possibly whether you need to give if you're going to deliver a telehealth service to a Medicare beneficiary that's not going to be covered because it doesn't meet those restrictions, maybe it's performed in an MSA, do you have to give an ABN? Because if the service itself is statutorily excluded, you don't need to give an ABN. But if it just is non-covered, you would want to give an ABN. And I don't think there's no statutory exclusion for ineligible telehealth services. So I think to stay on the safe side, if you're going to be doing telehealth for Medicare folks you're not meeting those restrictions, you want to think about the ABN route. And then the last one I have here is, can a Medicare Advantage plan provide telehealth services outside of the CMS site of service restrictions? So this is a really good question. In general, Medicare Advantage plans have to provide at a minimum the benefits that a Medicare patient would receive under original traditional Medicare. But they can always provide more. And so I believe there was legislation that they could, so the answer is they can always provide more benefits. And if an original Medicare person wouldn't get telehealth because they're in an urban area, the Medicare Advantage plan could certainly choose to provide more. I believe there was some policies passed earlier this year that made it more likely that Medicare Advantage plans would offer this sort of thing. So in short, the answer is yes, a Medicare Advantage plan may offer additional benefits, and it seems like that may be happening more often since those policy initiatives. We have a couple state-specific questions on prescribing that I think we need to get answers to offline, and we'll follow up with those folks. If you have any questions, please call us. We're always happy to talk to you and help you. Please join us next in December for our next webinar, and don't forget to fill out the survey.
Thank you.
Thank you so much.